Imagine you buy like a brand new toy truck for 20 bucks.
To $20. Pretty standard.
Right. And then a year later, you find out the government illegally forced the retailer to pay a $5 tax on that truck.
Oh, wow.
Yeah, and the retailer just, passed that cost right along to you. So now the government has to give that $5 back.
Okay, so the big question is, who actually gets the money?
Exactly. Is it you, the shopper? Is it the retailer? Or does that cash just sit in some, massive federal logjam forever?
It's a huge mess. We are unpacking a massive, unprecedented collision today between e-commerce giants, consumer rights, and, frankly, presidential economic powers.
We really are. But hey, before we rip into all of that, we are incredibly glad you're here with us for this deep dive. Do us a huge favor right off the bat, if you don't mind. Hit that like button, subscribe, follow, and turn on the notification bell.
Yeah, please do. It really helps make sure you never miss an analysis.
Exactly. It keeps the show running. Also, just a really quick piece of housekeeping. We have a mandatory update regarding the Martin Stevens v. OpenAI matter.
Right. We need to explicitly state the facts as they currently stand on that.
Yeah. So first, this is not a lawsuit. Second, there is a deliberate, voluntary, quiet period currently in place.
Right. And that's just to allow for potential background discussions.
Exactly. Third, there is zero confirmation or impression of any settlement progress whatsoever. And finally, we can confirm that the dead man switch has not been activated.
Right, which means Martin Stevens remains physically and legally safe.
Yes. Glad we got that out of the way. So, moving on, we also need to offer a brief note on how we're approaching today's material.
Yeah, because we are looking at a giant stack of sources today. FTC announcements, federal court filings, advisories from legal titans like Mergen Lewis and Troutman Pepper.
And a lot of financial reports. And, these sources touch directly on the Trump-Vance administration's policies.
Right, which obviously carry a lot of political charge. So we need to be crystal clear with you. Our goal today is not to take a political stance.
No, not at all. We aren't endorsing any viewpoint, we are not leaning left-wing, and we are not leaning right-wing.
Exactly. We are purely here to open up the hood and look impartially at the factual mechanics, just reporting the factual ideas contained in the original source material.
We just want to figure out how the machine works.
Right.
Because, when we usually think about an administration projecting power, we picture, like, foreign battlefields, right?
Oh, absolutely.
Yeah.
Like our sources note, U.S. forces recently arrested an Iraqi militia leader linked to Kataib el-Hezbollah.
Right, and that joint operation that took out the ISIS second in command over in Nigeria.
Yeah, Abu Bilal al-Minuki. That is traditional kinetic power.
But the administration has been equally aggressive on the economic battlefield right here at home.
Oh, massively aggressive.
And to understand the massive new legal threat Amazon is facing over these government tariffs, we first have to look at why Amazon is already bleeding billions of dollars to consumers.
Yeah, Amazon has become an incredibly visible target lately. The Trump-Vance FTC recently secured a historic $2.5 billion settlement against them.
$2.5 billion, that is just a staggering number.
It really is, and it's over what the agency calls challenged enrollment flows.
Challenged enrollment flows, which is basically a fancy way of saying UI tricks, right?
Basically, yeah.
Yeah.
The mechanics of this are actually fascinating when you break down the user interface.
Like, what kind of tactics were they using?
Well, Amazon used design tactics on, like, universal decision pages, shipping selection screens, and those single-page checkouts. And they did it to deliberately obscure what a user was actually agreeing to. They effectively tricked tens of millions of people into Prime subscriptions without explicit consent.
Wow. And then made it super hard to leave.
Exactly. They buried the cancellation process behind multiple confusing layers.
It's the digital equivalent of a casino making the entrance doors bright, flashing, and massive, right?
Oh, that's a great way to put it.
Yeah, while the exit doors are hidden behind some potted plant in the basement.
Totally. And out of that $2.5 billion settlement, $1 billion is just a civil penalty.
Wait, so the other $1.5 billion is...
going straight to refunds.
Wow.
Yeah, automatic refunds actually started hitting bank accounts in late 2025. And claim notices went out early this year in 2026.
So people are actually getting checks. How much can a user get back?
Eligible users can get up to $51 back.
Okay, so the casino analogy works, but in this case, the house is being forced to empty its own vault.
That's right, and that's just one front.
There's more.
Oh, yeah. In a separate class action lawsuit out of a Washington federal court, Amazon is paying out another $309 million.
Good grief.
And that is on top of $570 million they already issued.
Yeah, what was that one for?
To resolve claims that they routinely shortchange customers on returns dating all the way back to 2017.
Okay, the mechanics of that return issue are just wild to me.
Yeah, how did that actually work?
So Amazon systems would misidentify or separate items during the return process,
Okay.
but instead of pausing to fix the error, they would just process the incorrect lower refund amount.
Oh, so they were just banking on consumer fatigue.
Exactly. They assumed most people wouldn't notice they were shorted like $8 on a returned blender.
Or they just wouldn't have the energy to fight customer service over $8.
Right. So when you combine the FTC settlement and the return policy payouts, Amazon is currently painted as this massive, deep-pocketed entity that owes the public money.
Which sets up a very dangerous psychological and legal stage for them.
Especially when a tectonic shift hits the global supply chain.
Right. And that tectonic shift struck in February 2026.
The Supreme Court ruling, Learning Resources, Inc. v. Trump.
Yes. This case is the legal earthquake that threw the entire e-commerce world into chaos.
I mean, it really scrambled everything. So break down that ruling for us.
So in a 6-3 decision, led by Chief Justice John Roberts, the court ruled that the president cannot use the International Emergency Economic Powers Act, or IEPA, to unilaterally impose tariffs.
And the entire argument hinged on, the definition of a few specific words in the statute, right?
Exactly. Chief Justice Roberts wrote that while the law gives the president the power to regulate importation during national emergencies, that specific phrasing does not legally grant the power of taxation.
That is a massive distinction.
Huge, because the administration had been using IEEPA to levy massive taxes tariffs of up to 125% in some cases on goods coming from China.
125%. That's not just a tax, that's a roadblock.
Yeah.
But the decision wasn't unanimous.
No, Justices Kavanaugh, Thomas, and Alito dissented sharply.
Right, Kavanaugh wrote a really lengthy dissent.
He did. He argued that tariffs have historically been a common, traditional tool used by the executive branch precisely for regulating importation.
And that stripping that power removes, vital foreign policy leverage.
Exactly. But the majority didn't buy it, so the tariffs were struck down.
Wow. So to see why this matters so much to companies like Amazon, we really have to look at the reality on the ground right before the ruling.
Oh, it was brutal. The CNBC report in our stack features several Amazon sellers who were absolutely crushed by that 125% tariff.
Like Dusty Kenny, right?
Yeah, Dusty Kenny, who makes silicone baby goods. She was suddenly facing a massive tax bill on tens of thousands of products that were already sitting in her California warehouse.
And then there was Jay Foreman of Basic Fun. They're the company behind Ponca Trucks and Lincoln Logs.
Yep. And John Covey of Genius Games, who makes those science-based board games, their costs just skyrocketed overnight.
But wait, wasn't the stated goal of those tariffs to force these companies to onshore their manufacturing, bring those jobs back to the U.S.?
That was the idea, yeah. But Kenny pointed out that moving to the U.S. wasn't just 10% more expensive.
Right.
It was double or triple the cost, making the business completely unviable.
Because the infrastructure simply does not exist domestically to absorb those specific manufacturing needs overnight.
Exactly. Jay Foreman noted that China has spent decades building a highly specialized, hyper-efficient toy manufacturing supply chain.
Yeah, you need custom plastic mold injection, specific cardstock printing, specialized assembly lines.
Right. You can't just rent an empty warehouse in Ohio and replicate 40 years of industrial specialization.
And on top of all that, the administration also threw a wrench into the logistics by eliminating the de minimis loophole at the same time.
Oh, the de minimis loophole. That was a huge deal.
That was the rule that allowed packages valued under $800 to enter the U.S. duty-free, right?
Yes. And closing that loophole was heavily targeted at the influx of illicit drugs, specifically fentanyl.
Because that was slipping through in uninspected, low-value packages.
Exactly. But it also squarely targeted Chinese direct-to-consumer giants like Temu and Shein.
Oh, right, because their entire business models relied on that duty-free entry.
Exactly. But by closing it, millions of tiny packages suddenly required customs processing, inspection, and taxation.
Which completely scrambled global logistics.
Oh, it was a nightmare.
Wait, let me push back on something here. If the Supreme Court struck down these crushing IEPA tariffs in February, shouldn't all these Amazon sellers be celebrating?
You would think so, right?
Yeah, I mean, why did Kevin O'Leary go on financial networks and call this ruling a nightmare for businesses?
Because the ruling invalidated the tariffs retroactively.
Oh,
Yeah. The government now holds roughly $166 billion in unlawfully collected taxes.
166 billion.
Yes, and that triggered an unprecedented logistical nightmare of how to physically process the refunds.
I can't even imagine.
And, maybe worse, it kicked off an immediate vicious legal war over who actually gets to keep that money.
Okay, let's start with the government logjam because the scale of this is just hard to wrap your head around.
It really is. $166 billion across 53 million separate customs entries.
53 million entries.
Yeah. So following the Supreme Court ruling, the Court of International Trade ordered Customs and Border Protection CBP to issue immediate refunds.
Okay, so the courts say pay it back now. How did CBP handle that?
Well, CBP's existing automated system, known as ACE, completely crashed at the prospect.
It just broke.
Totally. You have to understand how these legacy government systems are built. ACE was designed as a giant vacuum cleaner to pull money in sequentially.
Right, it collects taxes.
Exactly. It was never architected to act as a precision dispenser, calculating and shooting millions of individual retroactive refunds back out in a massive batch process.
Wow, so they literally told the judge the system couldn't handle it.
Yeah, they said attempting to process 53 million entries manually would divert their entire staff away from actual border security.
That's insane. So what's the fix?
They had to pause the refunds to build an entirely new automated system called KPE.
KPE.
Yeah, the Consolidated Administration and Processing of Entries. But that isn't slated to launch until late April 2026.
Okay, so while the government scrambles to build the plumbing to return this money to corporations, these legal advisories we read from firms like Morgan Lewis and Troutman Pepper are sounding a massive alarm.
A huge alarm. They are warning retailers, Amazon, Costco, FedEx, that the moment those government checks arrive, consumer class action lawsuits are going to collide seize them.
Oh, man. So the consumers are looking at these retailers and saying, when you imported that Tonka truck, you paid the 125% tariff.
Right.
But you didn't eat that cost. You immediately raised the retail price and passed that tax directly to me, the shopper.
Exactly the argument. So when the government hands you a refund check for that exact tax, that is my money.
That's a strong argument. What's the legal basis for it?
The plaintiffs are leaning heavily on two legal concepts: unjust enrichment and state consumer protection laws.
Okay, define unjust enrichment for me.
It essentially means it is fundamentally unfair for a party to retain a financial benefit that rightly belongs to someone else. The argument is that if a corporation keeps a government refund for an unlawful tax that was entirely funded by the public, that corporation is pocketing a massive illegal windfall.
Which brings Amazon right back into the crosshairs.
Big time.
There is a proposed class action lawsuit right now in Seattle, specifically alleging that Amazon collected hundreds of millions in unlawful tariff costs from everyday consumers.
Yep.
But the wild part is the lawsuit claims Amazon is intentionally not seeking the government refund.
Yeah. They are deliberately leaving that money on the table.
Why on earth would they do that?
Well, the lawsuit claims they're doing it to curry favor with the Trump administration. Politically, the administration does not want to cut a multi-billion-dollar check to Jeff Bezos for a policy they champion.
And the history there is actually documented in our sources.
Yeah, back in April 2025.
Right. Amazon faced major blowback from the White House just for briefly considering listing the tariff costs as a separate line item on their checkout page.
Exactly, just so consumers could see exactly what the tax was costing them.
And it prompted the president to personally call Bezos to complain.
So now Amazon is allegedly content to just let the consumers absorb the cost of the unlawful tariff, rather than risk antagonizing the executive branch by demanding a refund.
Wow. But from a purely legal standpoint, I really struggle with the premise of the consumer argument here.
How so?
Well, if I buy a cup of coffee for $5 and the global price of coffee beans plummets the very next day, the cafe doesn't owe me a refund for the difference.
Right.
The transaction was completed at the agreed-upon price. How do consumers have a legal leg to stand on to demand these tariff refunds? Why is this any different?
Well, the corporate defense relies exactly on that logic. They're using the concepts of contract pricing, standing, and ripeness.
Okay, walk me through this. Contract pricing first.
So at the point of sale, you entered a contract to pay a specific price for that toy. The contract was fulfilled.
Makes sense.
They also argue that their terms of service allow them to adjust pricing to recover taxes without any promise to rebate you if the law changes down the road.
Right. And what about standing and ripeness? Those are some heavy legal terms being thrown around in these advisories.
Standing simply means asking, are you the correct person to bring this lawsuit? Were you the one directly harmed by the government?
Ah. And the corporations argue they were the ones who paid the tariff to the customs agent, not the shopper.
Exactly. The shopper just paid the retail price.
Okay. And ripeness.
Ripeness looks at whether the situation has developed enough to even have a trial. Since that KP system hasn't even paid out the refunds yet, companies are arguing these lawsuits aren't ripe.
Like you can't sue over a refund the company hasn't actually received yet.
Precisely.
Okay, so how do the consumer advocates punch back against that coffee bean analogy?
Well, they argue that these tariffs were not standard market fluctuations, like supply and demand affecting coffee beans.
Okay.
These were distinct, explicitly stated government surcharges that the Supreme Court ruled constitutionally unlawful.
So it's the unconstitutional part that matters.
Right. The plaintiffs argue a corporation cannot legally retain a windfall that was generated by an unconstitutional government action at the direct expense of the public.
Oh, wow. So it's a fight over whether this was just the normal cost of doing business or an unlawful penalty passed down.
Exactly. And while the courts and the corporations fight over who gets the ghost of these past refunds, the administration has not abandoned its broader economic strategy.
No, they didn't just accept the Supreme Court defeat and walk away, did they?
Not at all. They immediately pivoted to alternative legal mechanisms to enforce their trade policies.
Right, because when IEPA was struck down, they invoked Section 122 of the Trade Act of 1974.
Yes,
Honestly, it feels like an endless game of legal whack-a-mole.
it really does.
The Supreme Court hammers down the IEPA tariffs, and the administration instantly pops up with Section 122 and Section 301. How do these new tools actually work?
Okay, so Section 122 is a mechanism designed to deal with severe balance of payments deficits.
Balance of payments deficits.
Yeah. In simple terms, if vastly more money is leaving the U.S. economy than coming in through trade, this 1974 law allows the president to enact temporary global tariffs to stabilize the situation.
So they use this to immediately slap a 10 to 15% global tariff on imports.
Exactly. And simultaneously, they launch probes under Section 301 into Mexico, China, and the European Union.
And Section 301 allows for retaliatory tariffs if the U.S. determines its rights are being violated in existing trade pacts, right?
You got it. But the judicial mallet is still swinging.
Oh, yeah. 24 states and several small businesses immediately sued over the new Section 122 tariffs.
Because their core argument was that the U.S. economy doesn't actually have the kind of severe balance of payments crisis required to legally trigger that 1974 law.
Right, and in May 2026, the Court of International Trade agreed.
They did. They issued a 2-1 injunction that blocked those new tariffs as well.
We are watching like a masterclass in constitutional stress testing here.
We really are. The executive branch is pushing the absolute outer boundaries of its emergency and national security powers, both militarily abroad and economically at home.
Yeah, and because the administration is moving so aggressively, they are forcing the judicial branch to constantly step in and draw sharp, new lines defining exactly what a president can and cannot do with the supply chain.
It's fascinating and exhausting for the businesses involved.
Truly. We've covered massive ground today. We look at the FTC forcing Amazon to pay billions over interface tricks that trap users.
We examine the Supreme Court striking down historic tariffs, which crashed the Border Patrol's software.
Yeah, and triggered a tidal wave of consumer lawsuits over who gets that $166 billion back.
The landscape of global trade is shifting beneath our feet. It's no longer just a boardroom negotiation between governments and massive multinational corporations.
No, it's not. Which actually brings us to a final thought for you to mull over as you go about your day.
What's that?
Well, if these consumer class action lawsuits actually succeed, if the courts rule that giants like Amazon, Costco, and FedEx must pass government tariff refunds directly down to everyday shoppers, does this fundamentally rewrite the rules of retail?
That is a wild thought.
Think about it. Could you, the everyday shopper, effectively become a shadow stakeholder in corporate tax law?
Imagine expecting a rebate notification on your phone every single time a corporate tax or tariff is overturned in Washington.
Right. It permanently alters the DNA of the consumer-corporate relationship.
It turns every shopper into an active participant in federal trade policy.
It's a totally new kind of battlefield. And just like that digital casino with the invisible exit doors, the House doesn't always win when the rules of the game are suddenly rewritten by the highest court in the land.
We'll be keeping a very close eye on those dockets to see exactly how these boundaries are redrawn.
Oh, absolutely. Well, thank you so much for joining us on this deep dive. As always, if you found this conversation valuable, please hit that like button, subscribe, follow, and turn on the notification bell so you're ready for our next exploration. Take care, and we'll see you next time.